There is no evidence to be led here. Admittedly, there is a whip, Sunil Prabhu, on the 3rd, saying vote against the trust vote. Admittedly, on the record of the House, they voted in favor of the trust vote. Even by that time, Gogavale would not been appointed by the Speaker, though the Speaker has no right to appoint Gogavale. He appointed Gogavale on the 3rd evening, which he can't do otherwise, but that's another matter. So, what is there for the Speaker to decide? There's a violation. The vote is on the record. You're not usurping anything. You're only declaring.
This question is incoherent. This issue is incoherent. What is the logical follow-up? Then the Speaker will say it's per se case.
I'm sorry?
Speaker will say it's a per se case.
Yeah, I hope so.
You are.
I hope so, Malaz. I hope so.
That's a different matter. What you're trying to say in 3 is, in per se cases,
Yes.
should the court not decide?
Yes, that's the point.
That's
why I put per se there, Malaz. Only for that reason.
God. So that is incoherent.
Well, we have to ultimately persuade you, Malaz, so we have to.
Yeah.
I always say, without the court on your side, there's no point arguing. And the only way to have the court on your side is to be as reasonable as possible, though politics is essentially unreasonable. The art of politics is to make the unreasonable look reasonable.
Necessarily. Politics can be very reasonable also.
Directly in issue. Because of those documents, brothers, I've shown to your lordships already that you are removed from Assam, you are removed as the chief whip, and I continue to be the party and you are removed as lead. I continue to be the group leader. Directly in issue. Well, what you are doing in this process is sidetracking the disqualification proceedings, toppling a government, and then saying, now my speaker will decide. Actually, the constitutional premise and every constitutional authority should in fact help in ensuring that an elected government continues to be in power. Whereas it's something that I'm going to argue later, but I want to just tell your lordship something very interesting. Well, as a governor has to decide to administer the oath of office. So 30 people go to him, 20 people go to him. The governor must first know which party they belong to. Either it's a post-poll alliance or a pre-poll alliance, right? So the governor must first ask them, which is that party? Normally, their position, 39 members' position is inchoate. They can't represent the Shiv Sena. This is the first time this issue has arisen in this country. So, how does the governor decide that I'll administer oath of office? There is no party before it. I'm just touching it, Mullahs. This is an issue that your lordships will have to consider. So, Mullahs, let's come to 6. Should the governor, who is constitutionally obliged to sustain the continuity of an elected government, change the status quo by allowing for a change in government before disqualification proceedings are decided by the Speaker? Then next, whether the governor can swear in as Chief Minister a person against whom a notice for disqualification has been issued by the Speaker acting as a tribunal under the 10th schedule and is pending adjudication. What is the impact of pending disqualification petitions on the ability of members to participate in a test of strength on the floor of the House when their vote would have the effect of toppling the government? I can understand in a situation, Mullahs, that clearly doesn't matter, the outcome would be the same. But here the hard facts are, their vote topples the government. So you have allegedly, according to me, a member who should be disqualified, voting to topple an elected government without the governor asking him which party you belong to. Without the governor, Mullahs, even finding out for himself. Or the governor saying, look, there are some disqualification petitions. By this, an elected government will be toppled. Let's stay our hands. We will not administer oath of office till the disqualification is decided. He can say that. Should he say that? Should he not say that? That's, Mullahs, an area where, Mullahs, your lordships have never looked at, so to say. Well, obviously, it's premised on constitutional morality. Then, Mullahs, can a constitutional court in a matter relating to disqualification under the 10th schedule decide the matter on its own without referring the matter to the Speaker for decision? And if so, under what circumstances? This is directly what my lord put to me, and we are aware of it. If the decision of the Speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Because it relates back, Mullahs, he is the Chief Minister. What do we do? Which is why the Time is of the essence. What is the impact of removal of para 3 of the 10th schedule? I've already argued that. In what circumstances do the Speaker recognize the whip and the leader of the political party? I'm arguing that. What is the scope of powers of the Commission with respect to determination of a split? That's something I'll argue later. This is, according to me, the issues that your Lordships might wish to look into. Now, let's kindly have a look at my overview document, which is, and kindly have a look at outline and over PDF page 5 overview. Your Lordships may skip that. I want your Lordship straight away to take you to the issue of the whip. Chapter 7. Yes. Of whips and the role of political parties.
Which portion?
This is at PDF page 70.
No, which file?
Of the written submissions of petitioner, the same document.
Petitioner.
A written submissions A, of the petitioner. I hope to finish today, so that I don't take too much of your Lordship's time.
Did you say it's PDF page?
Page 70. 70.
Sorry. Yes.
Chapter 7. What is the scope and power of the Speaker to determine the whip and the leader of the House? What is the interplay of the same with respect to the provisions of the 10th schedule? The petitioner respectfully submits that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip and also the leader. Lordship, Justice Shah doesn't have?
Yeah, now.
Okay. Petitioners respectfully submit that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip and also the leader of the House Legislature party. The Speaker is bound to recognize the person who are communicated by the leadership of the original political party to be its whip and leader of the House Legislature party. The Speaker's role in this regard is merely administrative in nature. The Speaker cannot abuse his role to defeat the spirit and intent behind the provisions of the 10th schedule. Now, it is submitted that the respondent's case is hinged on a legal misconception that the whip under paragraph 2(1)b of the 10th schedule can be issued, changed by a majority of the members of the legislative party, which is what they did on the 22nd of June. The defense is in the teeth of the plain reading of 2(1)b, which my Lord has already read, So, that's exactly what we were wanting to do. A bare reading of the aforesaid provision would show that the framers of the 10th schedule were conscious that the disqualification was to be incurred for violation of the whip issued by the political party or any person or authority authorized by the political party. There is no reference at all to the legislature party in para 2(1)b of the 10th schedule. This distinction between political party and legislative party is also borne out from a reading of paragraph 1(b) and 1(c) of the 10th schedule, which brings out the difference between the meaning ascribed to the legislative party and the original political party. The respondents in defense have sought to intermingle the definition of political party with that of the legislative party and have sought to extrapolate the legislature party in the place of a political party in 2(1)b. It is further submitted that para 1 of the 10th schedule makes a clear distinction between the term legislature party and original political party. The term legislature party is defined as the group consisting of all the members of that house for the time being belonging to that political party. And the term original political party is precisely defined as the political party to which a member belongs. Further, the definition makes it clear that the said term is specifically defined for the purposes of 2(1) of the 10th schedule. In this regard, Kuldeep Nayyar's case, you'll kindly have a look at paragraph 4, just the quote there. Authorities are certainly not wanting, which indicate that courts should interpret in a broad and generous spirit the document which contains the fundamental law of the land or the basic principles of government. Nevertheless, the rule of plain meaning or literal interpretation described in Maxwell's interpretation of statutes as the primary rule could not be altogether abandoned today in interpreting any document. Indeed, we find Lord Evershed, the length and detail of modern legislation has undoubtedly reinforced the claim of literal construction as the only safe rule. It may be that the great mass of modern legislation, a large part of which consists of statutory rules, make some departure from the literal rule of interpretation more easily justifiable today than it was in the past. But the next is very important. But the object of interpretation and of construction, which may be broader than interpretation, is to discover the intention of the lawmakers in every case. C. Crawford, the object can obviously be best achieved by first looking at the language and used in the relevant provisions. Other methods of extracting the meaning can be resorted to only if the language used is contradictory, ambiguous, or leads really to absurd results. This is an elementary and basic rule of interpretation as well as of construction processes, which from the point of view of principles applied, coalesce and converge towards the common purpose of both, which is to get at the real sense and meaning, so far as it may be reasonably possible to do this, or what is found there laid down. The provisions whose meaning is under consideration are therefore to be examined before applying any method of construction at all. And 2.1a and 2.1b makes it very clear. Violation of the whip and voluntarily giving up membership. And Mullahs, your lordships with experience knows what act amounts to voluntarily giving up membership. We endorse and reiterate the view taken in the above quoted paragraph in the judgment. It may be desirable to give a broad and generous construction to the constitutional provisions, but while doing so, I'll just read this, to the rule of plain meaning or literal interpretation, which remains the primary rule, has also to be kept in mind. In fact, the rule of literal construction is the safe rule unless language used is contradictory, ambiguous, or leads really to absurd results. I'll continue after lunch.
Mr. Mahendra Singh, you're not the only person who's feeling hot in the court. We agree with you. We have to start the ACs.
Yes, Mullahs, your lordship should, Mullahs.
Mr. Mahendra Singh, is it the heat of the weather or the heat of Mr. Kapil Sibal's arguments?